Welcome, class, to Political Science 475, Constitutional Law. We only have 2 more sessions. It's kind of bittersweet, but let's really briefly go over a lot of what we've discussed really quickly, just to make sure everybody is 100% clear on these things. Natalie, if I say I have been discriminated against, I'm a victim of discrimination, I can file a lawsuit, and what will be my claim? What in the Constitution will I say is being violated? The Equal Protection Clause, right? Good. So, and a lot of the time when people have a discrimination claim, it's illegal to be discriminated against. We want to be more nuanced by the end of this course than that, right? Do a lot of laws discriminate against people on some basis?
Yes.
Yes, a lot of laws. Are a lot of those laws constitutional?
Yes.
Absolutely. Right? Largely due to the nature of the classification. Right? If you say I'm being discriminated against on the basis of age.
Yes.
Right? What test will the court apply?
Rational basis test.
Rational basis test. Outstanding. And what will they ask about the policy?
Is it a good means of accomplishing a necessary government objective?
Is it at least a rationally related means of accomplishing a legitimate government objective? Yes. And the burden's on the individual to prove that it is not, right?
Yeah.
Otherwise, the law will stand. So do we have a lot of laws that discriminate on the basis of age?
Yes.
Do we have a lot that discriminate on the basis of income?
Yes.
Yes. Why do we have so many laws that discriminate on the basis of age and income?
Because it's not exclusive.
Yeah, those are non-suspect classifications, and the court applies the lowest level of scrutiny. And if you have a law that discriminates on the basis of age or income, the court's going to strike it down. Or uphold it. Just leave it. Right? Then that takes us to intermediate or heightened scrutiny, which is what the court applies in gender discrimination cases. And the policy must be a substantially related means of accomplishing an important government objective. As Ruth Bader Ginsburg put it in U.S. versus Virginia, this is a very demanding standard, and it falls entirely upon the government, and they must provide an exceedingly persuasive justification for treating men and women differently. Right? Yep. And race is a good example of an inherently suspect classification.
Yep.
The court will apply strict scrutiny, and the policy must be the least restrictive or a narrowly tailored means of accomplishing a compelling government objective. Otherwise, the court will strike it down. Right?
Yep.
That's where we are. Okay, very good. Good summary. And we discussed sexual orientation the other day.
Yep.
Right? And where does sexual orientation fall in terms of classification?
I believe they put it, as of now, it's at rational basis.
Yeah, exactly. As of now, they've struck down any policies that discriminate against people on the basis of sexual orientation. They've struck down those policies on just using the rational basis test, right? The lowest level of scrutiny. So if you are an advocate for people who've been victims of discrimination on the basis of sexual orientation, you would hope that the court would up their level of scrutiny, right?
Yes.
But the court has not done that yet. Okay, now let's before we move on for the day, let's just discuss these different classifications. Do we have classifications based on disabilities?
Yes.
Yeah. Are people with disabilities often disadvantaged in our society?
Yes.
Yeah. Is that the result of conscious laws that disadvantage them, or is it more often just because of oversight?
Oversight.
Yeah, like you just forget to put in handicap ramps, or something. It's happened for a long time in our nation's history. And also, people with disabilities have been treated very poorly at certain times in our nation's history. So Congress passed the Americans with Disabilities Act, right? Have you heard about the Americans with Disabilities Act?
I have not heard about this.
Oh, really?
No.
Okay, yeah. Back in the early 90s, Congress passed the Americans with Disabilities Act, and it basically said that, someone can't be fired from their job if, with reasonable accommodation, they can perform the required tasks, right? And they must have full and equal access to facilities, a number of things like that, right? And don't quote me on those directly, but that's the gist of it, You need to make accommodations for people with disabilities in the workplace. We need to make accommodations and changes to buildings so that they have access to them, right?
Yeah.
Well, did that come from Congress or the courts? Congress, right? Now, based on our discussion, all those questions I asked you about classifications.
Yes.
Why do you think that came from Congress before it came from the courts?
I don't know.
Think for a minute. There's nothing wrong with thinking. Think of all those questions I asked.
I don't know.
Well, no. There's nothing wrong with thinking. Think.
I don't want to think. I just want you to tell me the answers.
Is your Uncle Greg in a wheelchair right now?
Yes.
Could I be in a wheelchair one day?
Yes.
What do you think keeps me from persecuting people who may not get around as well as they did before?
Because that could be you one day.
Exactly.
Uncle Greg has not always been in a wheelchair.
That's right. Unfortunately, he got multiple sclerosis, and there it is. Right?
Yeah.
So, human nature being what it is, what keeps me from persecuting people with disabilities?
You could be a person with a disability one day.
Yeah, there it is, right? And when you might be a member of a group one day, what happens to the level of scrutiny that the court applies? Higher levels of scrutiny or lower levels of scrutiny? Lower levels of scrutiny. So it's kind of interesting that Congress acted on that before the court did, right? Okay. Now, as you mentioned, discrimination claims are rooted in the 14th Amendment. It says no state shall deny any person within its jurisdiction the equal protection of the laws, right? No state.
Yes.
Natalie, am I, Carl Dorfler, the state?
No.
No.
You're not.
Can I decide who comes into our house and who does not come into our house?
Yes.
Absolutely. Why?
Private property.
It's private property. I'm not the state, right? There it is, right? And so, in order for you to make a successful discrimination claim, the state action requirement has to be met. And remember how I said the first thing the court will ask is, what's the nature of the classification?
Yeah.
That's true in a way. But actually, even before they ask that question, they will ask, is this private discrimination or is the state involved in the discrimination somehow in a substantial way? Right?
Right.
Okay. So, let's talk about the state action requirement. Because it needs to be met in order for a person to have a successful discrimination claim.
Yeah.
Okay. So, kind of, the huge case in this area was called Shelley versus Kramer. And it was decided in 1948. Okay, now, 1948.
Yes.
There were a lot of places, like St. Louis, where certain neighborhoods had what are called restrictive covenants, right?
Right.
And basically, everyone who lived in that neighborhood would enter into a voluntary agreement with other people in the neighborhood that they would only sell their properties to other white people.
Jeez.
Yeah. And they were called restrictive covenants. And everyone agreed to abide by them. And so you would say, I'm only going to sell my home to a white person. And our neighbor would say, I'm only going to sell my home to a white person. Right? Now, why would somebody do that back in the 1940s in St. Louis?
Racist.
Well, they're racist, and also they were trying to protect their property values because they thought if minorities moved into the neighborhood, that would lower their property values.
Which is, again, racist.
Well, yeah, it's racist, but there was an economic incentive as well.
Yeah.
Other than just straight out racism alone, right?
Yeah.
There was also that economic incentive. Okay, so nice African American family moved into a neighborhood. The restrictive covenants were supposed to be enforced, right?
Yeah.
And so they said, well, we wanted to buy the property and the people wanted to sell it, and there was no state law against it, right?
Right.
So here we are, and we should be allowed to live in this property. So the case went to the Supreme Court, and the Supreme Court said, how is the state involved here, right? And the attorneys for the family said, because the state, the government, is enforcing the contract. Now, what do you think? Government enforcement of a contract. Does that substantially involve the government and what's going on?
Yes.
Yes, exactly. That was a successful argument, right? So, in the majority opinion, they said the state action requirement has been met because the person who wants to keep this family out wants to bring the full coercive powers of the state to bear against this family. And at that point, the government's involved. Right?
Yes.
In our country, who enforces contracts?
The government.
The government. Exactly. Right? And so, state action requirement was met. Now, are people still free to have voluntary agreements with others that they're only going to sell their home to a certain person.
Yeah.
Yeah. But don't ask the government to come and enforce that if someone violates that agreement later.
Yeah.
Yeah. Okay. This takes us to Burton versus Wilmington Parking Authority. All right. Okay, what happened with this one was well, Nat, you learn a lot about a lot of things in here. How much do you think it costs to build a parking garage?
Doesn't it cost quite a bit?
Absolutely. Why?
A lot of cement.
It's a lot of cement.
It's a lot of structural integrity.
Very good. Why else does it cost a lot of money to build a parking garage? Those are the biggies. You know, people are like, oh, what's the big deal? That is a lot of concrete, right? And you've got to pour it properly. Otherwise, that sucker's going to come crashing down, right? And then what are you going to put on it?
Yeah. I've seen the ones in California. Those walls are thick.
That's thick, right? Because go back to my question. What are you going to put on them?
Cars.
People.
Heavy
yes,
people.
Heavy. People...
People have,
The point is, parking garages are expensive to build. It's a lot easier just to take up half of Alabaster and build a huge parking lot in the Colonial Promenade Mall, right?
Yeah.
Exactly. But anyway, and they decided to put in a parking garage, and guess what?
What?
Revenues from parking weren't going to cover all the costs of building the parking garage. What do you know? Because it was really expensive. So, the town, or the Wilmington Parking Authority, I forget which, but both are government entities, they decided to lease some of it to this guy who put in like a cafe, diner, little restaurant type area, right?
Yeah.
Okay. Now, and then the person said, no minorities allowed.
Oh.
Type of thing, right? Okay. So keep in mind this was 1961.
Yeah.
That's where we were as a country in 1961. So lawsuits filed, goes to the Supreme Court. And has the state action requirement been met? Supreme Court said yes.
Woohoo!
Yeah. Who decided to lease the property to that man?
The state.
The state, the government, right? So the government was substantially involved in their decision whether or not to lease the property, right? Now the guy had put in a fair amount of his own money to convert it into the facility that he wanted,
Yeah.
And so he was kind of feeling like, well, I'm the one that built this thing. I'm the one that invested here. The state's leasing me this space, but a lease by its very nature isn't the same as selling me the property, right?
Yeah.
You're just leasing it to me for a while. I don't think the state's that involved, but the Supreme Court disagreed and said the state action requirement was met, right? Okay, so Shelley versus Kramer, Burton versus Wilmington Parking Authority. are these victories for civil rights groups?
Yes.
Yes, they are. Because they were suggesting the state action requirement can be met at a pretty low level, pretty low threshold, right?
Yes.
And the state action requirement's been met. And so a lot of people thought, well, basically almost any time you have government involved in any way, the state action requirement's going to be met. So that takes us to Moose Lodge number 107 versus Irvis. This was decided in 1972. And Moose Lodge. What do you know about anybody with the name Moose Lodge? Nothing exactly. They were a gentleman's type club, and it was whites only, right? And so a guy who was actually a member of the state legislature had been invited there by his friend, went to go in, and they said, sorry, you can't come in on account of your race.
Racist.
He was African American. Yeah, there you go.
Okay.
All right. So again, he was African American, also a member of the state legislature. He was understandably upset, right?
Well, yeah.
So he filed a lawsuit, and the case went to the Supreme Court, and the Supreme Court asked his lawyers, why do you think the state action requirement has been met? And if you were a lawyer for this member of the state legislature who's also African American, what would you say?
I don't know.
Well, the Moose Lodge had a liquor license that was granted by the state. So the attorneys tried to make the argument, well, the state's involved here because they decided whether or not to grant Moose Lodge a liquor license, right?
Right.
So the court weighed that argument and said, nope, that doesn't cut it. Just getting a liquor license from the state does not substantially involve the state here in the discrimination or anything else that's going on. This is still a private club. Are there public roads that lead to the Moose Lodge?
Yes.
Yes. Are there sometimes public utilities that lead to private organizations like this?
Yes.
Yes. Water, electricity, gas, that type of thing, right?
Yes.
So the court said, you gotta draw the line somewhere, right? And just because there are public roads leading up to the building, just because they have public utilities, just because they get a liquor license from the state, doesn't necessarily satisfy the state action requirement. Does not mean that the state is significantly or substantially involved here. This is still private discrimination, not state discrimination. What do you think?
I mean, with the logic that they're using, I guess the government wasn't very involved in that aspect, but it still shouldn't be okay to discriminate.
Right. Yeah. But keep in mind, the 14th Amendment says no state.
Which is unfortunate.
Yeah. So, private discrimination is still allowed. State discrimination on the basis of race is not.
I see.
Any questions?
No.
All right. Well, it was a short lecture today. Tomorrow we're actually gonna wrap up with a couple cases that we didn't have a chance to get to. Most of you have already done everything. I'm just putting out this content in order to make sure you get everything out of the course that you were promised. A number of our lectures have gone a little over, so it's okay to have a shorter one. Take care. Hope you guys are doing well. Make sure you have gotten both your papers in and the assignment to do the assessment. Take care. Bye-bye.